with everybody here, we are back in session, so let's go ahead and get started. At this point, Mr. Mayhew was on the stand when we adjourned last, so Mr. Mayhew, if you will please come up.
We got a chair right up here if you don't, if that's okay.
I think we need to re-swear you.
Yeah, we'll swear you again.
And I apologize, I had to leave last time, but.
A bit brusque, but it goes that way.
What's that?
It was a bit brusque, but it goes that way sometimes.
I had to.
Do you swear or affirm that the testimony you are about to give to the commission is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Mr. Hicks?
Do you want me to just sit there? Okay, that's it.
Yeah, why don't you just sit there?
I don't want to feel like somebody's sitting behind me. So, Mr. Mayhew, thanks for appearing again. Hope I just have a very quick few questions. When we left your prior testimony, I think at one point you had claimed your analysis was that Gene Schmidt had double paid for some others, and that maybe was an error in your reading of the numbers on the invoices. Is that a correct summary?
Yes, when I looked at the invoices, it appeared to me that she may have paid twice for some of the mailers.
Okay, but then I believe.
But I didn't know how the invoices were
Okay, but
constructed.
but then I think we discovered that you had not considered that there was a numeric alpha character at the end of some of them that weren't on others.
That's
So
possible.
like a P at the end, okay. So I just want to ascertain that. Mr. O'Brien described you in an email as a proffered expert. Did you develop any report as an expert or consult any specific report?
I don't know what you mean.
And I think a lot of times an expert is supposed to they are either providing a report or they are testifying to a report. When you did your analysis, did you prepare any sort of report?
No.
So on what basis are you an expert? Other than your past occupation, you've been presented as an expert, but you're making representations, some of which we found are in error, and you never created any sort of report that you're testifying to. Is that correct?
Object to the question in the form referred to in the error.
Sustained, just ask your question.
So you presented as an expert, but you've not developed any report from which you're making that you're testifying to.
Correct, I was not asked to create a report.
So when you did your analysis of Mr. Schmidt's invoices, did you create anything? Any report, any document?
No, I just reviewed them.
So I would move that this man is not an expert. He's not proffered as an expert. He hasn't prepared any report, nor has he testified to any report, and I think all of his testimony should be stricken.
Let me respond.
Yeah, please respond.
There's no requirement that an expert produce a written report, and Mr. Mayhew was provided exhibits that are admitted or will be admitted or have been admitted before the commission. He reviewed those, and he giving, as I recollect, about 18 years of experience in the Secretary of State's office, including being head of the campaign finance section. He gave his opinion, and I think he's entitled to do that with or without a report. There was no need for a report.
He's also made representations as to how campaign consulting works when he's never been a campaign consultant, how being a candidate works when he's never been a candidate, how being a field worker works when he's never been a field worker, et cetera, et cetera. I mean, so I don't think this man is an expert. So I'm going to maintain my objection that if he was going to be presented as an expert, he needed to either have some report or not just come in and give his hearsay testimony on what he observed.
Well, I'm going to overrule the objection because my understanding is he was only presented as an expert as it relates to campaign finance filings. He reviewed the reports and he made his opinion based on reviewing those reports, and that's what's been stated and responded to here.
Did you review campaign finance reports, or did you review invoices, or did you review both?
I reviewed campaign finance reports, invoices, some correspondence, the usual kinds of documents that are typically filed with campaign finance reports.
So, just for brevity of speed, I know that in order to review campaign finance reports, there's some I can do online, but to actually review the actually filed reports, I have to do a record request. Did you do records requests to obtain the canceled check copies and things of that order, the original invoices that are not visible on the campaign finance site of the Secretary of State and only obtainable by doing a records request?
Well, as an electronic filer, I know that information is available online.
No. So you're presenting yourself as an expert, but for example, copies of documents are not available online. Like copies of checks, copies of original documents. You have to do a records request to get those documents.
Her data is
Let me get to a
available.
question. Let me get to the question. So one of the examples, just for sake of time, I'm doing this, was the canceled checks to Constant Content for the original set of invoices. The only way I got this was by doing a records request because there's the vast majority, and all original filed forms are not visible through the Secretary of State site. You have to do a record request to get the actual document. And you just represented that it's visible or that it's there. So again, how are you an expert when you don't know that the documents, the actual source documents can only be obtained by a record request?
As I said, as an electronic filer, her data is filed electronically and available electronically. Other additional information that goes along with the campaign finance report was provided in information Mr. O'Brien provided to me.
So you didn't get original documents from the Secretary of State site for doing an expert analysis?
Well, original documents aren't submitted with the SOS. Copies maybe.
Well, the original documents of the Secretary of State. So for example, if you look here, I don't think it's, as the Commissioner's point, it's Exhibit 6 on page 42 of my exhibit book. There's an example of a canceled check that I only obtained by doing a records request to the Secretary of State. Did you ever seen that check before?
I may have.
And how did you see it?
If I saw it, it was when documents provided to me.
Okay. But you yourself didn't do any, again, I don't mean to beat that horse, you didn't do any records requests to do your expert analysis to make sure that what you were being presented was authentic documents from the Secretary of State.
I did not make a records request.
Okay. I guess, again, I want to keep my objection standing to this man's testimony as being an expert, but I have no further questions then.
Mr. Mayhew, just recently were you asked to review some amended filings that were made with the Secretary of State's office?
I was, yes.
And were those amendments to prior reports filed by the Schmidt for Ohio Committee?
Yes.
And did that include an amendment to report to reflect in-kind contribution for R.J. Mancini from either ORP or the defunct House Campaign Committee?
Yes.
And would that be, once a candidate learns about an in-kind contribution they had not previously been advised about, would that be proper to amend that previous report?
Completely, yes.
And were you also provided an exhibit that was marked, I believe in this case it's 14 and 14A, that was a similar amendment to a prior report regarding outstanding debt to either Constant Content or Attorney David Goldstein?
Yes.
And when that additional outstanding and still disputed debt is learned, would it be proper to file that amendment?
Yes.
And you reviewed those and they were filed with the Secretary of State's office, correct?
Yes.
No other questions?
I have a So when were those filed?
I don't remember the date. I saw the printouts of the submitted information.
General time frame, a week ago, 2 weeks ago?
I don't know.
So if I told you that they, according to Mr. O'Brien's exhibit, that he
I have copies,
put in
yeah.
evidence, it was the 12th and the 15th of January?
Could have been.
So those
I
would
don't
be,
know.
so again, I'm a little confused on your testimony. Those are within, the 15th is within 3 days of now. And you don't remember when you reviewed them?
You didn't ask me that.
I think I did.
No, you asked when they were filed.
Okay. When did you review them? I'm sorry.
Yesterday.
Okay. Part of your review wasn't confirming that they were actually filed?
Well, of course they were.
Okay, but you didn't.
I didn't take note of when they were filed. I don't even know if that information, the amendment timestamp, it was on the document that I saw.
It's on the document that Mr. O'Brien has presented, so how thorough was the review then?
Well, I reviewed in terms of the content of the amended filing.
So your testimony last time was that there weren't any issues, and that was on the 26th of October, as I recall. So now that
Not based on the information I saw.
Okay, so part of the allegations of this complaint from the beginning were specific to R.J. Mancini's compensation. So when you previously testified, was that not something that you had ever looked at as an expert?
Mr. Mancini's compensation?
That was a direct part of the original complaint, by name, with his pay stubs.
I saw an entry, I think by the federal ORP account. But I mean, what are you asking me to attest to?
Well, you're saying you reviewed 2 filings, one for RJ, related to R.J. Mancini. And so I was asking you, had you looked at R.J. Mancini in your prior work because it was part of the original complaint?
I just looked at the documents that were submitted.
Okay, so when you were testifying before that there weren't any issues, that was only specific to the Goldstein invoices and not to the other allegations of the complaint?
No, it was
Jack, Your
two.
Honor, Madam, that isn't what he testified to.
No, my review was of the Schmidt campaign committee and the information that was known by the Schmidt campaign committee at the time.
But in your prior testimony, a significant part of it was specific constant content invoices with mailer numbers on them. That was the lion's share of your testimony. Is that not a correct statement?
Yes, there were constant content invoices with item numbers, canceled checks, payment history. But I don't think any of that included Mr. Mancini's name.
Okay, so I'm going to move on, but so that would mean you didn't review the original complaints as part of your review you did as an expert?
I did.
So you missed the whole part that was on specifically R.J. Mancini and his pay stubs?
I don't remember the pay stubs including anything about the Schmidt campaign.
Okay. Do you know about when this complaint was originally filed?
No, I don't know. I know it's been a long time.
So I believe the original, I'll even use a lesser date, if I'm the right one here, is that the original complaint was served on Ms. Schmidt on June 16th, 2021. There was a preliminary hearing and preliminary review on 8/12/2021. And then the next finance reporting was on January 31st, 2022. And the original, for your expert opinion, on the original complaint, they called out specifically that R.J. Mancini, by my own personal knowledge, had done work on the Gene Schmidt campaign and provided pay stubs that he was in fact compensated through the ORP. When, if a candidate became aware through an Ohio Election Commission complaint, for example, that there was an outstanding issue with the compensation of a person that worked on their campaign, when do you think is the appropriate time for them to report something?
I think it's most appropriate for a campaign committee to report the receipt of paid work that they received by others. When they know that the person was paid to be part of that campaign committee.
Well, but, so I'm pointing out that if they knew because of the complaint, do they have an obligation to take any steps to try to address it, understand it, or clean up their financial report at that time?
If the complaint contained specific verified information about that person being paid to be part of that campaign, I believe I would look into it further. But merely attending an event or helping with a parade, that doesn't automatically assume that the person's paid to be there.
I would agree with that, but we're talking about a series of events here that go back more than 2 years, in which Ms. Schmidt has had access to R.J. Mancini all that time. He came in here and easily testified about the percent of time worked on the campaign. Did she have do you believe as an expert in campaign finance that she had a responsibility to clear that up when she became aware that there was likely or highly potentially an issue? Or was it my job to clean that up by forcing a hearing here?
No, I think.
I'm gonna object to the
Understood,
legal
okay,
comment.
just answer the question.
I think once Mr. Mancini testified that he was paid to be a part of the campaign committee, which I think was only recently done, then I do think the campaign committee should update their information, which, from what I can tell, they did.
So I think he testified in September of this year, but he also testified several years prior in another matter. So, but just, I don't know, my question is, do you think that at the moment he then, if it wasn't 2 years earlier, at the moment he testified, there should have been some action?
I think the trigger is once the committee knew that a person was paid to be part of their campaign committee, that they should update their filings.
Okay. So there's various statutes that are involved in this case. One is the one, I won't quote the numbers, but failure to file and complete an accurate statement. Failure to, which there's various elements of that statute based on pre-primary, primary, post-primary. They're dealt with, for some reason, the legislature had to be all different total sections of the code. Then there's a thing about corporate contributions, and the parts of the statutes about complete and accurate statement never contain the word knowingly. But the section of the code about what would amount to a receiving an improper corporate contribution exogenously has the word knowingly. Could you, as an expert in campaign finance, comment on the import of the word knowingly and how it relates to campaign finance statutes in Ohio?
Well, the knowingly standard does come and go throughout the statute. I don't
I don't mean to interrupt you, but just to be clear, the statutes on failure to file a complete and accurate statement never contain the word knowingly. Would you agree with that statement? You don't know, or what?
I don't know what the statute says currently or during this particular period of time, only because I've been separated from that work. But I do know that, you know, when a campaign committee files a report, they do so under penalty of falsification. And, you know, because the amendment process exists, I think it presumes that there are times when a campaign committee has additional information that they have to supplement previously filed reports to include that information.
So I would represent to you that the word knowingly, as Aubrey said, is in the corporate contribution statute. It's not in the other statutes, but you would assume in your mind, because people can file amended reports knowingly, as somehow implied within those statutes?
I couldn't attest to that. I don't know.
Okay. And the definition of knowingly, since it's an important matter in this case, and it can be an important matter in campaign finance, prescribe for me what you think under Ohio statute, which is 290122B, what knowingly means, and what the duty is of somebody that's related to knowingly.
Object is a statutory definition that speaks for itself.
I asked him, as an expert, what does he believe it means?
And whatever he believes it means is irrelevant, it speaks for itself. In the English
He can have
language.
his opinion as an expert.
Don't let him state his opinion.
Yeah, I don't know what the bright line of knowingly is. I think this commission is probably going to make that determination based on the information it has in front of it. I do think there may be one or more elections commission advisory opinions that have dealt with, maybe not defining the term, but have dealt with issues of knowing in campaign finance.
Okay, so they, just to close out this area. So if I want to figure, the whole statute on knowingly is about 5 sentences. The last part, they basically have to do with, if you believe something could likely be happening, there's the actual words are such circumstance probably exists. The term probably exists, that becomes knowingly. But it's interesting, and I just want to get your comment as an expert on it. It also, in the statute, points to knowingly being when you fail to make inquiries, when, or make a conscious purpose to avoid learning a fact, is being an example of knowingly doing something you intentionally don't. Have you ever encountered that in your expertise, in your expert role in campaign finance, of that kind of distinction?
No.
Are you aware of that distinction?
Not specifically, no.
Okay, specifically, I want to be real clear. Specifically, I'm asking the distinction that a part of the legal definition of knowingly is when you fail to take action that a reasonable person would have because you become aware of circumstances. So you're aware of that, or did that?
No.
Okay. I don't think I have any other questions.
I think just a couple to make sure I understand. You were asked in the context of knowingly, Mr. Mayhew, to give an opinion whether a candidate can report an in-kind contribution that they have not been advised about. And when they fail to do it, are they knowingly filing an inaccurate report? If in this instance, neither ORP nor OROC told Ms. Schmidt, we paid Mancini to work for you, can she, if she lacks that knowledge, include that in her report?
Of course not.
And when she doesn't, she is not knowingly filing a false report. is she?
Wait.
I object because he's putting words into that are not even the questions I asked.
Okay, that's fine. State your objection, but he needs to,
No, it's not what I'm objecting.
And
He hadn't finished his question.
He had, yeah, because he was still, yeah.
I think I'm just trying to get to the point, Mr. Mayhew, is that can a candidate file or be accused of filing an inaccurate report when no one has told them about the in-kind contribution that should be included?
They cannot.
Okay, and that was the point of the knowingly that we discussed, I believe, at the last hearing. Just so we're clear about what we're talking about, if I may approach the witness and show you an exhibit.
Sure.
I'm going to hand you, and I think Mr.
I haven't seen the exhibit, I don't have the exhibit, I don't know.
They're in your hand, Mr. Hicks, you asked him about it. It's exhibits 13
Well, that's not the
and
exhibit.
14. Well,
And then I have all the exhibits in a book, so he can turn to the page.
the new ones too?
I don't agree to the addition of some of those new exhibits.
I know you don't, but I can ask the witness if he's seen them and reviewed them.
Does the commission have these new exhibits that he's?
I gave them to Mr. Richter.
They've been submitted and circulated to commission members.
I have them right here.
So Mr. Richter already communicated, I have a stern objection to an affidavit being filed as part of an exhibit from a person who's a party to the case, or that being circulated to the commission.
If possible, you may be able to cross as it relates to that affidavit. We'll see.
So if I may
Yeah.
show Mr. Mayhew, these are exhibits that were submitted to the Secretary of State and that you were asked about. Could you look at those exhibits 13, 13A, B, and C, and 14, and 14A? And are those the items that you looked at and were testifying about in terms of an amendment?
Yes.
The 13A is an affidavit which I object to. It's not proper to file an affidavit while there's ongoing testimony in a case. It's not been subject to any cross-examination, and I don't even know if I will be able to cross-examine it.
Okay, understood.
And at least my question was whether you saw those, Mr. Mayhew, and I think the presumed answer is yes.
Yes, I did.
Okay. And are those the amendments that were made to the prior campaign finance reports that we testified about?
Yes.
And the exhibits, do they reflect the outstanding debt that we talked about to Constant Contact that was disputed between $1 and $18,000 and change? And then secondly, the in-kind contribution from ORA.
Can you point to what specific exhibit, what specific number you're talking about is on? You're making just these general statements about numbers that I don't even know what exhibit number I'm on.
I think the question was to Mr. Mayhew whether he's recognized those and whether they reflect the outstanding debt.
I don't know which specific exhibit you should be looking at as you're asking these questions. If you be precise as to what exhibit you're asking about. There's like 4 of them here.
Yes. If I may
You're talking about
approach,
13A?
if I may approach the witness, Madam Chair, 13A, is that is the affidavit. We're not talking about 13A. We're talking about 13 in the first instance. Is that a standard Secretary of State online copy of an uploaded document to them?
Yes.
And
What number is that on?
that's
13.
That's 13. And if we look at 13B, is that a standard online printout exhibit of what was filed as an amendment? And it is for the outstanding debt of between $1 and $18,000 and change to Constant Contact, correct?
Yes.
And then if we look at 14A, that's the face sheet, 14, that's the face sheet of a similar filing for Mr. Mancini's in-kind contribution. And 14A reflects it individually.
Yes. This
Hold on,
is-
which one?
14A and 14.
Do you not have a separate copy for yourself or something?
No, this is my copy I'm showing to Mr. Mayhew, who didn't bring his copy. I have no other questions. Thank you. Thank you, Mr.
Hold
Bond.
on, I have a quick redirect on this, if you could look at, can you let him have your copy so I can?
Yes, sir.
So, just for me to understand this, and if the board, the commission have these,
Yeah,
they'll look at them?
we all.
So 13B, what is that showing and what's the $1 on there?
Well,
13B,
yeah, this is a submitted cover page of a,
what is it showing, not what is it showing?
it's showing the statement of financial condition for the semi-annual report in July of 2023. One of the,
So when Mr. O'Brien just questioned you on this one, he said it shows an outstanding debt between $1 and $18,862. Can you point, you said respond in the affirmative, can you point to on this exhibit where it shows a debt between $1 and $18,000?
I think the question was 13B and C. C shows the detail.
I asked you a question specific to 13B.
Okay,
Is
there's
there anywhere on that exhibit that it shows an outstanding debt between $1 and $18,862?
It does show an outstanding debt.
That's not the question I asked. The question was, is there anywhere on this, on 13B that it shows a outstanding debt of between $1,000 and $862? Yes or no?
It shows a debt of $1 because that's a limitation of the filing system. There's no way to put in a span.
So
in
the answer to my
cover
question
page.
is no.
On the cover page, no.
On 13C, okay, where does it show a range of between $1 and $18,862?
In the detail of the debt itself,
So, isn't that just the description? So somebody put $1 to $18,862 in the description, but the
it's the
actual.
only place it can
Can
go.
I finish? But only reported $1 in the actual amount. Is that a correct understanding of this report?
In an electronic filing, a span of funds cannot be entered in the financial line items. So there has to be a place to put that span of funds other than in the actual,
Okay. So what would be the criteria by which you would actually have the number that goes into the computations of the reports be entered at $1 versus, why would you have it be $1 versus the worst case scenario of $18,862?
Well, obviously, I did not submit this report. I think it's reasonable in a circumstance like this to report it this way, since the outstanding debt is unknown at the time of the filing.
But you would agree that the outstanding debt is known to be, the debt based on the invoicing would be $18,862, is that correct?
I don't,
Jeff, there was no invoice for 18,862. That was the balance.
yeah, and yeah, so what's the
The
question?
difference between the invoice that was presented to the client and the invoice that then was then negotiated and paid was $18,862, is that correct or incorrect?
I believe that's the amount of dispute.
Okay, so why would you, in campaign finance, when that situation occurs, and it involves a corporation, which constant content is, where there's special laws around corporations, why would you say you would recommend reporting $1 versus reporting what might be the maximum extent of the debt?
Well, I don't think I said I'd recommend. I can see it being appropriate to report it this way.
Why would that be appropriate versus reporting what the maximum liability could be that you were invoiced?
Because it's unknown, as disclosed.
So, as an expert, if I were a candidate and had work done from a corporation and the bill was $50,000, and I said, well, I think it was only $10, it's okay for me just to report $10 as the debt?
As long as the matter is under dispute, I think so.
But you're aware of the different rules for corporations than versus if this was an LLC?
They are treated differently.
Okay. All right, I have no other questions.
I don't have any other questions. Thank you, Mr. Mayhew.
Well, wait,
Oh, excuse me, commission members. Sorry.
commission members have any questions, Mr. Mayhew?
Yeah, I have one. So, Mr. Mayhew, you said, I'm sorry, my exhibits are sideways, so that's why my head is tilted. So in 13B, I'll, refer you to it, where we had the outstanding debt owed by the committee, it says $1, and I see on the 13C, it has the 1 to 18,862. Correct me if I'm wrong, but I thought your testimony was, you said on 13B that the system,
Don't break your neck.
that's all right, that the system could not enter the 18,862, is that accurate? Is that what I heard you say?
No. It could. You could report the higher figure. You just can't report the range.
Okay.
I don't think it's a free
Okay,
field.
okay. That answers it, thank you.
Can I ask a question, Mr. Hicks?
Absolutely.
So, beginning of the examination, you basically sought to establish that Mr. Mew was not an expert, and then during the course after that, you referred to him as an expert like several times. So, is your position he is an expert or is not an expert?
No, my position is he's not an expert,
Okay.
and he did not do thorough research, so I apologize if I'm confusing. I'm using the expert statement a little bit cynically in saying that, because I don't think he's done a lot of research into this. He was just brought here to testify to things that were beneficial to the respondent.
Thanks for clarification. Thank you.
And that question as well. Any other questions? So, at this time, are you both done completely with Mr. Mayhew to not be recalled at all? Okay.
Yes.
You are excused. Thank you for coming in.
Thank you, Mr. Mayhew.
Absolutely. Sure.
Okay. So at this point,
So here's Katie.
At this point, I think pursuant to the commission rules, I'd offer exhibits and the testimony of Mr. Mayhew, exhibit 13 as well as 13A and B and 14 and 14A.
Well, the only, if you're offering the affidavit, I think the person who's submitting the affidavit needs to be subject to cross-examination.
Okay.
So if you're wanting to, after that, I'd say, okay, we'll take the exhibits, respecting Mr. Hicks's objections, but then, Ms. Schmidt would need to be available for cross-examination based on the affidavit.
Right, and at least, I think your rules do permit the affidavit to be submitted as part of the Secretary of State's records, and at least is it your view for the affidavit to be used that the witness needs to be called as well?
I believe so, yes.
Okay, so at least we could recall Ms. Schmidt explain the affidavit, and again, only for the purposes of discussing the affidavit, not the entire case.
Correct.
Okay. Just want to you testify here, Ms. Schmidt.
so all questions will need to be directly around the affidavit.
Correct.
Ms. Raymond.
Do you swear or affirm that the testimony you're about to give to the commission is the truth, the whole truth, and nothing but the truth?
So help me God.
Thank you very much.
Yes, Ms. Schmidt, your committee did file amended reports just in the last week.
Yes,
And the documents we've been talking about included in the documents because of the reporting system with the Secretary of State. They require an affidavit be submitted in unusual circumstances. This being in that category, were you asked to review documents and to sign an affidavit that was included with those amended filings?
yes,
And you have seen us talk about an exhibit I'm going to hand to you, and it's Exhibit 13A.
yes,
Is that the affidavit that you both reviewed and signed?
yes,
And I don't know if the commission members remember, your treasurer, longtime treasurer, was your now deceased husband, correct?
yes,
And did you get a new treasurer who is preparing and filing a report that's due the end of the month, and also prepared the 2 amendments?
yes,
And who is that person?
Mary Jane Campbell.
And did you request Ms. Campbell as your treasurer to file amended reports that reflected an outstanding debt disputed in an unknown amount between $1 and $18,862 to Constant Content?
Yes,
And was that report filed and shown in those documents?
yes,
And were you also asked, or did you also ask your treasurer to file an amended report regarding compensation of the Republican Party and OROC and/or OROC provided to R.J. Mancini?
yes,
And did you ask your new treasurer to amend the previous report to reflect approximately 10% of what was paid to him as an in-kind contribution on the report?
yes,
And to your knowledge, your treasurer did that, correct?
yes,
And is that the information that's contained in Exhibit 13A, the affidavit that was submitted to the Secretary of State's office?
yes,
And at least Mr. Mancini, or excuse me, Mr. Hicks asked about Mr. Mancini. You are aware that previously in this case, Mr. Mancini signed an affidavit, correct? And actually that was admitted into evidence.
yes,
And in that affidavit, did Mr. Mancini say that he was not compensated and paid specifically to work on your campaign?
yes,
And that was signed and filed as Exhibit 12, I believe. I'm looking for it here.
Exhibit I.
I think at different hearings, these things have been,
Now, what is the scope here, because we're going into other exhibits?
well, I'll limit it. I was trying to clear up the question that you had asked about the Mr. Mancini, but I'll not get into that. I have no other questions, Ms. Schmidt.
thank you.
So in the Exhibit 13A, the, Mr. O'Brien just questioned you on the Mancini 10%, $688. On what did you base the 10% in the calculation of $688 and change?
On Mr. Mancini's testimony here.
So, anything else, just his testimony?
That's all I had to work with.
Okay. Then why didn't you make the amendment when he, approximately when he testified, going on, I think, 4 or 5 months ago?
First off, I was in the process of finding another treasurer. And secondly, I wanted to do legal research to make sure that I could do that.
your testimony early in these hearings was that when you became aware of the complaint and you became aware of the specific allegations relating, for example, Mr. Mancini, that you never talked to him. And that would date back to what, summer of 2021, to ask him. Have you ever asked R.J. Mancini, outside of hearing him talk in this hearing, for him to quantify the amount for you?
He quantified it at this hearing.
That was not my question, Ms. Schmidt.
No, because he quantified it at this hearing.
Well, that hearing was, I think, let's see, more than 2 years after the complaint. So I'm asking, in that intervening 2 years before he testified here, did you make any effort to even ask him?
He signed an affidavit saying that he never worked on my campaign.
That's not what his affidavit said.
His affidavit said that he never worked,
His affidavit, if we want to get into it, his affidavit said that he wasn't directed specifically by the ORP to work on your campaign,
correct.
which is different than that he worked on your campaign.
I never knew that he worked on my campaign. That's the whole issue here. I never knew whether he did 1 day, 1 minute, or 1 hour. Ever, Mr. Hicks, ever.
But you said,
Please let me finish my sentence. Thank you. As I said, all throughout this testimony, I ran my own campaign. I did my door knocking. When COVID hit, then I was relentless on phone calls and other ways to contact voters. I had no knowledge that anyone was working on my behalf, door knocking, outside of the volunteers in the scope of my friends and family.
so just for sake of time, yeah, I'd ask you to have your answers be responsive to the question. So my line of questioning was specifically around since my complaint. So once you became aware that there was at least an allegation relating to R.J. Mancini more than 2 years ago when I filed a complaint, did you take any step to actually talk to R.J. Mancini himself before you heard him later, 2 years later, testify here to the 10%?
No,
Okay. Are you aware, you put in the affidavit earlier, if you go kind of midway down the page on 13A, it says, campaign Schmidt for either knowingly, recklessly, or negligently. Okay, so do you know, are you aware of the legal definition of the term knowingly?
I have to have firsthand knowledge.
So a person has knowledge of circumstances when the person is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established, if a person subjectively believes that there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. So I just read the legal definition of,
I'm objecting,
Knowingly,
it's not the
knowingly.
definition in 290122B.
I just read it, it's exactly what I read.
You see it?
I read the statute.
You read a form that you had typed up.
My question specifically, are you aware that part of knowingly under Ohio law is when you don't act? That you know that you should do something, but you don't do it?
I believe that's recklessly. I will object.
We can
Mr.
dispute whether I
Hicks.
read the statute
Mr.
correctly.
Hicks, Mr. Mancini filed an affidavit that he never worked for me.
That's not what his affidavit said.
He said he never worked,
He said he wasn't directed to
he
work.
wasn't directed to work for me. I took that at face value.
So even after my complaint with his pay stubs and his prior testimony about work in another matter before this commission, you never felt it was worthy of asking him in the intervening 2 years?
I don't know what the other matter was. It wasn't here with me. What are you referring to?
So let me retract the other matter and just ask you, in those 2 years, you never took any step to ask R.J. Mancini to tell you how much he thought he had worked on your campaign after there was a complaint for 2 years?
No,
Okay. Do you know where RJ Mancini works?
I think he's now working on the campaign. He has moved around.
Is there, when he testified here, is it correct that he worked for the Ohio House Caucus?
For a while, yes.
Okay, so would you say you have access to RJ Mancini if you wish to talk to him?
I don't have his phone number.
Okay, so also in your affidavit, on the second page of your affidavit, you said my campaign, kind of looking at the second sentence there, my campaign negotiated a settlement of an invoice, paid $22.60, which was filed both as debt and then payment of the, okay? And then you make reference in here, I think it's on the front page, to the 18,000, or is it here somewhere? 18,862, it's at the bottom of that paragraph.
Yes.
Okay, at this point, do you dispute whether all, I think 7 of the mailers in question that were on the Goldstein invoice, what I'll call the Goldstein invoice, took place?
Yes,
You dispute that they took place?
I don't dispute. I dispute,
Question is all 7.
all 7, I dispute.
Are you aware that I tried to have former Representative John Becker subpoenaed for this as a rebuttal witness?
Objection.
So this is a question, are you aware?
It's irrelevant.
It's not relevant.
It's not relevant.
Well, it's relevant in that I've asked for a rebuttal witness that's ready to testify to all 7 of the mailers.
I'm
I've been-
object and move
I-
to strike.
And I'm just asking her if she was aware of that.
Object and move to strike and ask for a ruling.
You're going to sustain the objection, move on.
So she's disputing, you're disputing that those mailers took place.
I'm disputing whether they took place or how many took place, what the actual cost of the mailer was, what the mailing fee was, etc. Just because it shows that something was printed doesn't necessarily mean that it shows that it was sent. Also in campaigns, you might have a universe of 100,000 at the beginning, but as people vote, you peel them off and so the number is reduced. Or you may only be targeting certain individuals. When you do phone calls and find out that Mrs. Smith is going to vote for the opposition candidate, you strike Mrs. Schmidt off the list. So Mrs. Smith, I guess I said. So I wanted to know actually how many were sent, who they were sent to, what the amount was, what the upcharge was, and those things were not available.
For the 4 invoices the 4 mailers you paid for, did you get that information?
No,
So why did you pay for them?
because I felt an obligation, as I said
I think
before.
we're getting beyond the
Well, we're getting
affidavit.
beyond, look, I'm an honest person. And I get a bill a year and a half after the election, when everybody is gone from the scene. And I don't know whether I owe it or not. And I thought, you know, I probably owe at least some of this. And I called Mr. Goldstein and it took him, what, how many months to call me back to try to resolve this? And I said, I need some proof. And he came up with the figure, and I said, fine, that's the figure I will pay. But again, there was nobody to call to say, how many did you mail? What was the price of the mailer? What was the upcharge of the mailer? What was the universe? Normally, you can do that at the end of a campaign if the structure is still there.
Just for sake of time, I'd like the witnesses to respond to the question.
Well,
I
think,
did.
yeah.
So do you consider yourself a pack rat that, some people are pack rats that save all the mailers they get and some aren't? Or you a pack rat that saves those kind of things, political mailers?
Not all of them, no, but for mine, yes.
Okay. Did you, when the allegations came out of the mailers and all 7 mailers, you and I live in the same district. I know who some of the people are that are pack rats that save all this stuff, like John Becker will be an example. Did you go at that, have you ever gone and asked some of the people that we both would know that save all these things, whether they had such mailers?
I didn't receive such mailers.
How do you know that? You said
Because
you
I
only
didn't
saved
re-
some of them.
I received 4 mailers on that.
So you're
You
now
said-
you're saying the 4 that you paid for them because you received them?
Yes. I was supposed to receive every mailer that was taken, that was sent. That was part of the contract, no matter whether I was on the list to get them off or not. I was to receive every mailer. I only received 4. It said 7. I wanted to see what was going on. Nobody could tell me when they were mailed, who they were mailed to, etc., because the campaign apparatus was gone.
Isn't it true that you didn't have a contract?
I had a verbal contract, not a written contract.
Okay. Isn't relating to the mailers in your affidavit, didn't Megan Fitzmartin testify that no mailer was created or mailed without approval, without engaging the candidate for approval along the way?
It was supposed to be, yes.
So the 4 that you claim that you paid for and that you received, you approved those with Megan Fitzmartin, but the other 3 you did not?
I'm not sure because I'm not sure what 4 was alluded to in the actual payment that I created.
Well, there were specific numbers, and
Well, I don't know, Mr. Hicks. I got
So then-
4 mailers. I couldn't remember 18 months later what I approved, what I didn't approve.
but you said you received those 4, and that's why you paid for them, which would require that you
But
check
I
the
wanted-
numbers on the mailers to know that those were the 4 that you received.
Okay. I received 4, I didn't receive 7. That just because they create a mailer doesn't mean the mailer is mailed.
Doesn't creating a mailer involve work?
Yes and no, it requires artwork, period, but you don't print it.
But your allegation is the three that are now you're saying are disputed debt between 1 and 18,862 did not happen. But you're reporting them now as a disputed debt.
It could have happened, Mr. Hicks. I can't verify it. That's why it's a disputed debt. If I could verify it, I'd pay it.
So when you became aware of this, did you do anything to try to verify it, like contact people like John Becker who are pack rats in our community to ask them for copies of all the mailers they
I
got from that
didn't-
election cycle?
I didn't know John Becker was a pack rat. I didn't know that he received 7 of
Everybody
them.
knows John Becker's a pack rat, aren't you?
Well,
I think
unfortunately,
we should
I
stick
didn't.
to
I think John
facts.
Becker's outside the scope of the affidavit.
Okay. So the last part on the affidavit is, the last paragraph is about Tommy Rolfe, Stephen Caraway. So I don't think Stephen Caraway in his testimony here had any question that he was compensated. And he testified that he worked with you almost daily. But here you say you have no specific knowledge that they were paid specifically to work with you. So did you think that Stephen Caraway was volunteering without getting paid, contrary to his own comments?
That isn't what Mr. Caraway testified
It is. The question was where that got shown on your finance report, not whether he was compensated.
It doesn't show that the entire, I forget what the organization was called,
to.
was JPL was compensated. They were compensated through the literature and the upcharge on the literature, on the,
Hold on.
let me please, I just
That's
want
not
to
the
finish.
question. I just
No.
want you to address the questions I asked, not go into these long.
They were I'm answering the question, sir. They were compensated through the organization, through the upcharges that were made with the creating of the literature, the creating of the media, the distribution of the media. In fact, in the media, there were several upcharges that were made in the continuum, which is normal in a campaign.
Can I just need it, because we're limited on time here. So the statement in the affidavit is, I have no specific knowledge that Tommy Rolfe, Steve Caraway, or Luke Householder were paid to specifically work on the Schmidt campaign.
Correct.
So Steve Caraway testified that he was directed and paid to work on your campaign. Is Isn't that correct?
He was directed and paid to work at the organization. Part of that was my campaign. Part of that was the other 60 people that were running.
Okay, but he testified that you were one of the people that he was specifically directed to work with.
Mr. Caraway had to work with a lot of people.
I just asked you
I don't know that, sir.
You don't know if you were one of the people he was specifically directed to work with?
He was directed to work on every single campaign, period.
I guess the reason I'm asking the question is the affidavit says you didn't know he was specifically, but then you talk about the 10%. I thought your
What was the 10%?
the plus up, the markup on, I thought that your explanation was that, yes, Stephen Caraway was compensated to work on your campaign, but that compensation was covered within billings for mailers as part of the 10% markup. I thought that was your prior testimony,
For
but now I'm confused.
Well, you should be. In campaign organizations, don't take words out of context, sir. In campaign organizations, you have a director, you have people that work within the office, and individuals that are part of that, just like the structure we have now. I don't pay them specifically to work for my behalf, but I pay through the media, the mailers, etc. That allows that organization to be able to operate on my behalf. So did I directly pay Mr. Caraway or the rest? No. I indirectly paid them through my mailers, through the media, through the radio, etc. Just
Okay.
as I will be doing in the future
But-
with whomever is out there.
So just so I could get an answer. So is the answer then that yes, Stephen Caraway was specifically directed by the household organization to work on your campaign and was compensated? Not how that got
He was
reflected.
specifically asked to work on everyone's campaign and was compensated through the organization.
Okay, the 10% markup claim, other
Yes.
than your own assertions and an exhibit prepared by Mr. O'Brien, what other evidence do you have that the 10% markup, it was covered the field staff? If any evidence that other than your own
The
statement?
usual practice, and I've been at this a long time, is that there is a plus-up when they do your mail. You're not told what the plus-up is. It's anywhere from a quarter to a penny on the plus-up. At the Capitol, most of them do about 25 cents on it, but there is one, and I'm not going to give the name, that does a full penny on it instead of a quarter of a penny, but a full penny. So if you have 10,000 pieces, that's 10,000 pennies. That helps them cover their overhead. Every time that it goes out, that helps cover their overhead. You can go to printers and figure out what's a better printer to use on your own. And I've done that on campaigns when I didn't have to have any direct access. I've looked and shopped at vendors to figure out who was cheaper, only to find out that my friend who had competition in the campaign was charged more. Why were they charged more? Because of the plus-up.
Okay, so you're.
If I was running and I didn't have any competition, I would not be using somebody to help me win an election.
At this point, is your testimony that the plus-up was an exogenous part of your verbal contract for Steve Caraway, Tommy Rolfe, and Luke House, and not Luke Householder, I don't know, which is a different animal, but those two? That was an exogenous part of your verbal contract?
It's part of the, I don't understand what you're saying. Nobody said, here are all the people that are gonna work on this campaign. The verbal contract was, we're going to manage your campaign.
Okay. So was there a discussion of a specific plus-up or anything like that as part of that
No.
verbal contract? Okay. The constant content, it says in your affidavit above there, amended reports to outstanding debt to constant content or JPL Consulting. I'm confused by that because there's no disputed debt involving JPL Consulting, right?
Constant content does not exist, so any money would be going to JPL.
Why? They're not, one's a corporate separate entity. That'd be like saying Exxon doesn't exist, so I'll pay my bill to Shell.
JPL, at least Jeff Longstrop exists,
So your view is that the debt to,
then I wouldn't know a debt, would I? If there's nobody to give the money to, I wouldn't know the debt, correct?
well, in a campaign situation, if there was some nefarious activity like what happened with Larry Householder and the entities don't exist anymore, are you aware of where the money should be going?
I know I have to pay it, if I owe it.
So let me just give well, who do you pay it to legally? Who are you supposed to pay it to in that situation?
According to what I was told by David Goldstein, this is what you should do. And he was the debt collector. In fact, I would pay it to David Goldstein for Constant Content or JPL, because he's the debt collector.
Okay, but, okay, have you relating to this debt or these payments ever contacted the FBI or any other legal authority?
No,
I'm going to object again, we're outside the scope of what I understood we were going to be asking.
Well, not at all, because she's claiming she added JPL as part of the debt, which has never been part of the thing about the debt. Constant Content's a corporation that's gone because of legal issues, and under normal law, the money should be going to governmental authorities to compensate for the prosecution of the criminal activity.
And that explanation is wide afield of the affidavit, I understood.
Well, and my my understanding, tell me I'm wrong, is that there was at least a relationship between Constant Content and JPL.
But first off,
Correct?
no,
There wasn't?
no, other than having the same principal, be saying that Jeff Longstrop is the principal of both organizations, but they're two separate, distinct legal entities. One was a corporation, one was an LLC. I think they're both defunct at this point because of criminal activity they were involved in. So right now, if one had a bill, just to give an example, if I had a roof put on my house for $10,000, and then the company that did the roof got indicted and went away and all, I don't get to say, oh, now I don't have to pay the $10,000. The $10,000 legally goes to the authorities when there was criminal activity involved. So I'm just asking Ms. Schmidt, did you take any effort to contact any legal authorities with what happens to outstanding monies that were owed to what were later deemed criminal enterprises that are defunct?
And
No,
again, I'm
because I
going to
would
object,
make-
it's irrelevant to this
I would make it to
proceedings.
David Goldstein for him to do it. The debt collector was David Goldstein, that's who I answer to.
But whether they're. but you
Mr.
never-
Hicks,
you
I never
comment-
thought of it, no, because I would never think
Can
of
I
it.
ask the chair, it's supposed to be a witness, not having an argument back and forth with me with her randomly saying things. So the
But she had
point,
already answered you that she did not contact the FBI.
okay. Do you think that you should have contacted any legal authority about where the money should go?
No.
Objection.
Why is that an objection? Why would you have an objection?
She answered.
She's answered in that it's irrelevant to who should be paid.
Okay. I have no further questions.
I have no redirect.
Oh, I apologize. I have one further question. Because we're care about campaign finance and law. You filed this affidavit, but originally you refused to file an affidavit, in this case, a response affidavit, when it was called for within the election commission rules, because you claimed filing an affidavit would subject you to criminal prosecution and couldn't do it.
I'm going to
So why
object.
did you file this one?
I'm going to object to his characterization as to what Ms. Schmidt thought and why she did or didn't file an affidavit previously.
Sustained.
You did not file a response affidavit as covered in OEC rules, for whatever reason. Now nor did you submit the discovery. So, but now you're filing an affidavit. Why the change of heart with filing affidavits?
Again, I'm going to object. It was required by the Secretary of State in order
Well,
to
let
file.
her answer that then.
It is my understanding that I was required to do this by the Secretary of State.
Do you have any evidence of that in a letter or anything from the Secretary of State?
No, it was required by the Secretary of State.
Isn't that hearsay, basically? You're saying this, but you can't.
According to my attorney, it was required by the Secretary of State.
I have no further questions.
Still no redirect, Schmidt.
Wait,
Oh, excuse me, I'm very
sorry.
sorry.
any questions from commissioners? Hearing none.
Oh, no, I'm sorry, I
Oh,
may
I'm
have
sorry.
one. Let me keep going. No, I have one on here. So, Ms. Schmidt, what, do you remember the date that you had the new treasurer? When was that date? Roughly?
No.
Okay.
So,
I might follow up, is that after your husband passed away?
Oh, yeah,
Yeah, and he passed away when?
August,
Okay, so it was after that, but you don't remember the specific.
yes.
Okay, so it was, okay. Sorry about that again, but okay, that helps, thank you.
okay, so if no one has any further questions, may we excuse Ms. Schmidt? You're not gonna, okay, you're good, okay. You're excused. Thank you. Thank you.
And at least, I have no additional witnesses, but would move to admit all exhibits that were,
Can we do it, like, another hearings I can do it, is exhibits admissions at the end, that's what always has happened here, so.
Mr. Richter?
Okay, are you essentially resting testimony?
I'm resting, subject to the moving and admission of my exhibits, correct?
Okay, thank you.
1 through 14A.
I'm not prepared at this time to address which of these exhibits I'm admitting, so that's why I would prefer to, like, let's get the whole thing done, and then we can figure out the exhibit admissions.
Well, you've rested your case, what else is there?
Closings, right?
Well, but entry of exhibits would come before closing.
Okay. So
Do
which,
you need a minute?
yeah, so. Are there any of your exhibits, Ron, that you don't think were used?
I do not believe so, Mr. When you say used, I'm not sure exactly what you mean. For example, I think Mr. Seacar's affidavit was identified and used. I think Mr. Mancini's.
Okay, I don't object to any of your exhibits.
Okay.
Now, I'd like to move to admit all of my exhibits subject to this list, because there were some that were not used.
You provided at the last hearing a list of those that you were offering and
Let me finish
some
my,
that
let
you-
me address admitting my exhibits, and then you can start talking.
Yeah.
So what I've done
So,
is-
1 through 14A of the respondents' exhibits are admitted, and you have a list of exhibit admissions that you just handed. And I don't object to any of the ones marked in red that say admit. I don't know if you have that, Mr.
I don't have
I
it
don't
here
know what
right
you're
with
talking-
me
I
at the
don't-
moment, but I know I have it back in my office.
Those are yours. Okay, so you're commenting on your, oh, okay.
I'm talking
By the way,
about,
I'm colorblind, Mr. O'Brien, so when you say red, you know, it
There you
takes
are.
me a second to tell, what are you talking about red?
if I may approach Mr. Richter, I'll give you this.
I can give it to him since it's my thing.
I'm trying to facilitate this, Mr.
Okay.
I have extra copies, so anybody else has got like 7 copies.
All right, thank
So
you.
that, what you find on there is I crossed out any exhibits that I don't believe were used, that were my exhibits. So I would move to admit all of my exhibits that are marked on there as having been used. And do you have any objection?
Okay. No objections for his?
No objections.
Mr. O'Brien, you did realize there were some on the back as well, right?
Yes.
Those are his.
No, those,
Okay.
Yeah, those were mine.
yeah,
Okay.
responded to
And I
that.
just want to
Sorry.
make sure
Okay.
one thing,
Just want everybody to flip back and forth.
hold on, I just want to make sure one thing. Yeah, I think it covers all of my, just want to make sure that I didn't, because that's what I had that figured in the last hearing. Yeah, okay, that's all.
Okay.
And all those exhibits haven't been admitted, is that correct in red? I mean, yeah.
All they
Where
did
the
is
word
not cross
admit,
out.
either the word admit or read is there.
Okay, and at least if the evidence is closed, I'd renew my motion previously made for directed verdict, understanding that the commission likely would want to hear closing arguments, but I want to make that for the record.
Okay, thank you. We're ready to go to closing arguments then?
Yep.
I was suggesting limiting closing arguments to 5 minutes. I mean, if you need less than that, that's fine, but
I suggest that I've been managing the time we have approximately an hour left till the hard stop. So I'll try to stay within a brief period of time, but I don't want some arbitrary 5-minute thing.
Well, then you have to understand that we also need time to debate after. You can't go up to the 5 minutes because we also are gonna have conversations around it once you're done. I mean, you know, that's our time where we can actually.
Well, you can also do this in other cases where you take testimony or closing arguments, and then at some point, either here or another thing, if you're deliberating.
and that's a possibility
Right,
as
so-
well, depending on the timing, correct.
So it's,
Okay.
Madam Chair, since it looks like we're gonna go till 5, could we take 5 minutes
Yes,
for a
absolutely.
restroom break?
Okay.
Thank you.
So, it's 4:02, and we're going to take a short 5-minute recess to 4:05, or 4:07, excuse me. 5 minutes, we'll be done.
So I'm going to direct you, this really isn't, I said Ron handed out something that's more of a written up thing. There's just a few things on what I handed to you all that I want to be able to refer to, it's just some timeline stuff and things like that. So I think at this point, one of the things in my closing I want to get is I think that a lot of this is broken because I don't really believe we even should be here because this could have been resolved prior to there ever being a preliminary hearing, a preliminary review with some diligence. And I apologize to the degree of this is the way I am, those of you know, is grind it till it gets to the truth. And I think we've got to the truth based on the new campaign finance filings. The truth is there is some amount of outstanding debt that was never reported up until those filings, and we can dispute the $1 versus what should be reported, or the denial whether certain activities took place, which would call into question why report something that you claim didn't happen. Is that even disputed? If it didn't happen, why is it you wouldn't even say it was even disputed? So we've sat here and I look at that timeline, so the first page, and the question I hit on knowingly a couple times here, but you can look at some of these dates about when I filed a complaint. And what I want to point out is, somebody can make the case that they filed a complete and accurate, to their knowing, even if knowingly applied. It wasn't a strict compliance statute. But that wasn't true on the highlighted line. January 31st of 2022. So remember, this complaint was filed in June of 2021. And so the complaint in Ohio campaign finance law, in the term knowingly under law in Ohio, is that when you become aware that a situation might exist, could exist, probably exist, you need to take diligent action. And if we in a society don't have politicians that feel that they need to take diligent action when they become aware of things and can stretch it out for a couple more years, that's a problem. So I'm not making the argument. I'm not even making the argument that Ms. Schmidt, let me say I would give her that she could maintain, well, that before your complaint, I didn't knowingly. I think it's personal, I think it's a little bit ludicrous. I live in the same district, I think it's ludicrous, that assertion, but let's say you accepted that assertion as true. I knew nothing about this, you filed a complaint. From the time I filed a complaint with very concrete information in it, like pay stubs, specific names, because I had personal knowledge of these people. I had conversations with R.J. Mancini. I had lots of conversations with Steve Caraway over the course of these things. I had personal knowledge. You can say, okay, well, I'll give her a pass on that she didn't know this thing. But come, almost, 6 months after I filed the complaint, after there had been a preliminary review, after it was held over, and you're still not doing anything to fix it. Her own testimony is, instead of going and taking the simple, prudent, reasonable person things, go talk to R.J. Mancini. Go talk to Steve Caraway. Her answer on the testimony was, no, I didn't check any of this. I got a lawyer. That was her exact answer. I got a lawyer. That's broken. So I don't think there's any question that first, ultimately, I'm right. Her campaign finance reports were not complete and accurate, period. End of discussion. We know that because she just filed changes to them. I was correct. So if you say that, well, these aren't strict compliance statutes, and even though the word knowingly is not in them, that we should grant that, we should say knowingly. So my point is, at what point does it get so ridiculous that you didn't know that it defies any credibility? And I read the definition of, statutory definition of knowingly, which by the way is on the back of this, a couple times, because people don't realize that knowingly doesn't just mean you know, it means you consciously act in a manner not to find out. That's part of knowingly. And I would assert to you that certainly from 6 months after I had filed a complaint, and there had already been a preliminary hearing, so a preliminary review, I could use the wrong word, it defies any credibility to not have taken reasonable action. Frankly, I think Mr. O'Brien brought up at some point it was a close vote or something, and it got re-voted, on even holding it over for a full hearing. Had instead of the response been, I got a lawyer, the response been to make a few calls and do what she did 2 years ago, more than 2 years ago, 2.5 years ago, okay? We wouldn't be here. You wouldn't have had to listen to me for however many freaking hearings we've had on this matter. And so I think that this is actually an example of where you guys, not only to me there was a clear violation that's admitted to effectively by the filings, but also where the person involved denied, took no steps, diligent steps, like call R.J. Mancini. To get to the bottom of it, so that you can just fix it. And now thinks they can waltz in at the 11th hour, 3 days before this hearing, on the 15th, file amended campaign finance reports and say, hey, never mind. I didn't do anything wrong. You shouldn't find any violation against me. Everything is good. This is all just an ugly precedent. I think you guys as a commission also need to think about these precedents of people not filing response affidavits, not being willing to submit the discovery, taking things out. This is kind of, what do you call that, like the rock meets the immovable force. I'm pretty diligent, pretty persistent. But it usually ends up that what I'm saying is right. And I think we have that. And change your campaign finance reports, I was right. But now to come in and say well, there was really no violation, you can't allow this kind of behavior from political candidates. Because we shouldn't even have had to have any of these hearings. She just should have fixed it. She just should have taken the diligent steps of a reasonable person when confronted with an allegation to go at least talk to the people. It wasn't like I gave some just generalized allegation. You had people work for your campaign that, I gave very specific, pay stubs. In the original complaint, the pay stubs were in there. So I think there is definitely a violation. I think that the basis for that violation should be, if you look at the yellow on here, the yellow line, 711 days ago. Which, by the way, is how many days since the first amendment, because she filed 2 amendments, one on January 12, 2024, and one on January 15, 2024. That's how many days it's been. Not since I filed my complaint. My complaint, I don't know if I have the number on here. My complaint was filed, I didn't put it on here, but my complaint was filed far before that. It was on 889 days since she, by certified mail, got the Goldstein invoice. 889 days. Well, I know that's at least a couple of years. And we're just now reporting that the ones that were missing. So, if you look at the third page of this, it says law. got it?
I somehow didn't get a copy
Oh.
of this.
I put one on every person, I have an extra. I was just looking, why is Mr. Knight not looking at
I
this?
didn't want to, somehow I got skipped.
I don't know, I apologize. So the law stuff, you know, what I did is I put all of the things that were, where probable cause was found in the preliminary review, and these are important terms, you know. It was probable cause found in the preliminary review to have a full hearing where it's my obligation to prove these things, you know, that there was a failure to complete an accurate statement. The whole top part of this are just variations on that same theme, because as I keep pointing out, the statutes have like separate sections for annual, semi-annual, primary, you know, there's, for some reason, there's these separate sections. And then corporate contributions, and I highlighted the word knowingly there because that's the only place that knowingly is in this. So if you go to the back page of this, very last page, it talks about what's the standard here for a violation. Mr. Ricker can correct me, but it's a preponderance of the evidence. What does preponderance of the evidence mean? It's more likely to have happened than it didn't. This isn't like a criminal trial where it's beyond a reasonable doubt or what have you. This is preponderance of the evidence is what we're doing here. And so, however you slice it, first off, I was right. They weren't complete and accurate financial statements. Second off, a preponderance of the evidence would tell you that she should have been able to clean this up a long time ago. Instead of stretching this out, causing me to drive like a maniac, you know, here today. Going on and on. Still sitting here denying that certain mailers took place. Not taking any of the reasonable steps. How is it that I'm not part of the campaign, I'm not part of Ms. Schmidt's operation, I can get all this stuff, but she can't? And it wasn't that hard. The getting the mailers, I just never thought about it. The biggest issue was I didn't think like, I should go to some of the PAC rep people and see if they have copies of all these mailers within the political community in Claremont County. So if you look at these dates, you know, and the points, you know, I think that there's absolutely a violation here. And I think one of you said on one of the motion for, to dismiss this previously, like, well, there could be a just cause or due cause or whatever. No, this is something that has been stretched out and stretched out. I apologize if you think it's because of me, but I'm not the one that could have had it end way sooner, other than by not pursuing it. That's the only way I could have had it a lot of it end sooner. What's so funny about me is a lot of people think, or they misjudge how much I'm willing and will press on these things until we grind it out and get to the truth. There's not a lot of citizens that would do that. I think we need more of them. And you guys should think that's a good thing, that you have citizens that go out there, not on some witch hunt nonsense, but on, they were right. It was wrong. And let's not forget, I don't know how many other cases you've had come before you that deal with Larry Householder stuff. I don't know, as far as I know, I'm the guy that, but this was a pretty significant problem in Ohio politics. And there needs to be some accountability. This culture of, you know, what's so funny to me is I think I deal with people locally, somebody running for school board that's freaked out about having to come here. They're freaked out. They think, oh my God, they're going to lock me up or something. They take it seriously. The politicians that have been involved forever and ever and ever and ever and sophisticated, we give them a lesser standard. So I think you should use something like the 711 days. You know, you guys at some point you'll get to the point of if you find a violation and then you get to what's the fine. You know, you can figure it's a per day. I got that at the bottom of here. It's a per day, you know, range and so on and so forth. And then it's reasonable to figure out what's the day. That's the start day of when it should have been done. So when did the violation begin? And that can be subject to some discussion as well. But I would tell you this. The amount of money involved in that one invoice and the R.J. Mancini money is about 19 grand. I think the fine should be at least 19 grand. She's probably never gonna pay that $19,000. We have a defunct company. I think she'd be kind of foolish to pay $19,000 really to a defunct company. She should report it to the authorities. Let them figure out what to do about it. So, you know, I looked a little bit, I know Mr. Bryan's gonna have a convincing close, but he handed out this thing and it has the word knowingly over and over. And then it has, later it starts to slip to the word intentionally false. You know, you're getting pretty slippery when over 2 years, you're having to use a lot of the word knowingly and intentionally false, and you just filed new campaign finance reports to fix your campaign finance because I was right. So I know there's tragedy, there's irritation with me. Probably not a lot of you guys want to hang out with me. But I am passionate about the idea that we've got to clean up campaign finance in Ohio. And it starts right here. You're the body. If you don't get passionate about it, who can get passionate about it? And I can bring them in, and I hope the next time, maybe if you quote unquote throw a little something at them, the next time I find one of these, I still have one coming up, maybe the politician will think, you know what? I shouldn't put Ohio through this. I should fix my campaign finance report and not assume I can grind it the other way and get somebody like me so worn out that I just give up and walk away. The last thing I want to hit on in my closing is that this kind of middle section right here on the back page, allegations and a complaint. We got them right on the Mancini, we got them right on the mailers. I know the respondent disputes, but I think I'm right on the Caraway, but it doesn't matter. Because once there's been a violation, the point is you have the ability to fine a range of money, doesn't matter whether there were 10 violations, 20 violations, for $1 million, for $500, for $10,000. The point is there was a violation. And then what's your determination of what's the appropriate fine and what's the start date from which we calculate the appropriate fine. And I just think that, like I said, you guys have an impression of me, but I really think in our state, I take a lot of, I don't know if pride's not the right word, I'm trying to think of the right word. I think clean campaign finance and respect for the law is important. And after what happened with Larry Householder, it's more important. And the funny thing about it, I don't know those of you that have been involved in political campaigns, know that what happened in some of these things happens in a lot of campaigns. And it gets wink, wink, nod, nod, nobody's really there, doesn't get brought forward. It takes somebody like me to bring it forward. And it's got to start, we're not going to fix it. Whatever you do today is not going to fix it. But it can start moving the right way. So maybe the next generation of state reps that are coming up are a little more diligent because they know I could actually be held to account on these things. So I appreciate all the time of the commission on this case. I'm glad that Ms. Schmidt has endeavored to fix her campaign finance reporting because it was inaccurate. I hope that the commission doesn't now allow, after all this, the notion of at the last minute somebody filing a campaign finance report amendment to claim I'm not responsible, why don't you tell there's no violation. I think it makes it worse, actually. She could have done what she did 3 days ago, 2 years ago. And this wouldn't have all happened. Thank you.
Thank you.
Thank you, Madam Chair and members of the Commission. 2 years ago, Ms. Schmidt had Exhibit 11 and 12 in her possession, which were affidavits filed by Rob Secor, Executive Director of the Ohio Republican Party, and Mr. Mancini. Ms. Schmidt testified previously that when this complaint was received, that she turned it over to her lawyer. And she, like any other person who received that or any other kind of complaint, doesn't go out and try and do their own investigation, their own defense, start calling witnesses. Their lawyer will tell them, you gave it to me, let me handle it. And those affidavits from my contact with both Mr. Seacard and Mr. Mancini were sworn to by me as a notary, and they're in the record. And both those affidavits, they say, I was not paid to work on Gene Schmidt's campaign. I didn't direct from Ohio Republican Party for Mr. Mancini or any of these other people. I might add that both the original complaint and the amended complaint claim Mancini, Householder, Rolfe, Caraway, all were paid to work on the campaign when that is not proven. Rolfe sent 2 emails, go to some meeting, if you'll remember, and to take a picture. Householder, all we've seen is a picture of a truck in a parking lot in a hotel in Claremont County. And that's the allegation he made under oath, totally unproven. The other allegations he made were checked out originally, and both by Cindy Mancini and Mr. Seacard from the Republican Party said, we didn't pay or direct him to work on the campaign. That's because she wasn't an endorsed GOP candidate. The money went, and Mr. Seacard properly reported it to the House Republican Campaign Committee. He reported an in-kind for Mr. Mancini, he testified, to the House Republican Campaign Committee. We saw some, and they're in evidence, emails from Sue Jones, who's the campaign treasurer for the campaign committee, who asked Anna Lippincott, who you'll remember worked with Megan Fitzmartin at JPL, who are we going to report received an in-kind from ORP and or the campaign committee for the House? And Gene Schmidt's name was not on that. And therefore Lippincott didn't send out an in-kind to her. ORP didn't send an in-kind to her. And when she and her treasurer filed the report, it was accurate. Now, Mr. Hicks wants to make this a moving target. He filed this complaint on June 16th, I believe it was, of 21. He amended it in August. He didn't amend it to include any of this other information. After Goldstein, he didn't amend the complaint to claim the Goldstein matter was improperly reported. I heard you talking this morning about limitations to the 4 corners of the complaint. The complaint here doesn't mention Dave Goldstein, doesn't mention any mailings. The complaint is completely devoid of any claims that we failed to report a mailing. But nevertheless, we heard in a hearing room that, and Mr. Goldstein came in and testified. Mr. Goldstein said, I was a hired collector, I sent out bills. Ms. Schmidt paid a 50% negotiated amount. And that was because they couldn't prove, and he testified that if he had to go to court, he couldn't prove that $39,000 invoice. So she negotiated it because he said he felt she was an honest person. Ms. Schmidt wants the report she files to be accurate. They were accurate pre-primary and post-primary. There was a $164,334.31 invoice that she received March 18th. She paid $100,000 of it, reported the total amount of $164,000. She then paid the balance of $64,000 at the next opportunity to report. And I would add, continued on that was a service of $24,875 for mail. So she thought she had got an invoice from Constant Content. It included media, photo shoots, and mail. When she gets this invoice from Mr. Goldstein a year and a half later, dated November of 20, she gets it in August of 21. She again turns it over to me, and there's an exhibit in there, an email from me to Mr. Goldstein and him to me, when I said, what's this all about? Again, I'll get back to you. He didn't get back to us for months, but essentially he was said, you know, you invoiced us a year and a half later, prove it. And he was unable to prove it. But again, because she wants to be fair and wants things properly accounted for, she could identify about half of that invoice that she did owe. So she paid $20,260. She reported it as an outstanding debt, then she reported it as an expenditure that she paid. Again, everything completely 100% proper when she found out about it. Subsequently, we hear Mr. Mancini first in another hearing, and I believe it was in the Freeman hearing, when he was inquired about what he had done on Freeman's campaign and or Ms. Schmidt's campaign. He testified he went door to door twice for the Schmidt campaign. We've heard her say how she does her door to door. How are you going to report on someone who's paid, even if you know about it, to door to door? Subsequently, when he testified in this case, when Mr. Hicks pressed him on, give me an estimate on the amount of time that you worked on the Schmidt campaign, he said approximately 10%. So we filed 10% in-kind contribution from ORP and or OROC. And technically, if OROC had properly reported it to us, it would have been $688. They didn't report it to us, but because we heard about that in these hearing rooms, we filed the amended report. Mr. Hicks wants to say we waited till the last minute to do it. We are not going to take his word in a complaint filed 2 years ago that it's the gospel, take it to the bank truth. And we have seen and found throughout this process, it's a moving target. The question is, has he proven what he swore to under oath almost 3 years ago, that a false and inaccurate campaign report that wasn't complete was filed? And that simply isn't true. There's a complete failure of proof as it relates to Mr. Mancini. We then proved by looking at invoices. The invoices from Strategic Media to Constant Content were for hard numbers and hard work. Constant Content jacked that up 10% across the board. At 10%, again, I'm hiring you as my campaign consultant, you do what's necessary to get me elected, whether it's grassroots, whether it's polling, whether it's getting printing done, doing mailers, all those things are part of that package. Mr. Carraway himself testified, he as a political consultant does that. He said, I can't keep track of what all I do on each campaign every day. He said, if I work for 3 minutes or 8 minutes or an hour for Ms. Schmidt, and then for Mr. Freeman, and then for one of the other 10 people that were on that list, I don't break that down and then in-kind them. It's part of our overhead for JPL. Constant Content was the media arm. So we paid 10% more than the media production and the airtime, radio, and TV. We paid that 10%, and it was part of the package deal. We don't have to separately report it, and we didn't. And there's no evidence Householder even worked on the campaign. So at least I think the commission, in looking at this, we decided to make sure the record was clear as we're finishing this hearing. So the record's clear. There are some outstanding issues there, not because Mr. Hicks brought them up, not because he's proven it, but we want the record to reflect what we best know. And what we best knew was this 10% in-kind contribution, in-kind by ORP to OROC to the Schmidt campaign. And then secondly, to this minute, we don't know if we owe anything to Jeff Longstreth, who's awaiting sentence in federal court, or his two companies. And they're all together. There's Jeff Longstreth, two companies. Ms. Fitzmartin testified about that. So we don't know if we owe them another penny. And actually, we're not positive that that $20,000 we paid them was accounted for. But we wanted it behind us. She wanted a clean report. She wanted it to be accounted for. So we paid the $20,000 on a negotiated basis. And if you look at that second invoice, it said disputed debt paid in full. And that's what Mrs. Schmidt knows. That's what she reports. And that's what her new treasurer followed up and reported last week. So Mr. Hicks has a burden of proof. We submit he has not met that burden of proof, and that the commission should dismiss the case and enter a finding of no violation. So I want to thank you all for your attention.
Thank you. So at this time,
Conversation, deliberation. If anyone on the commission wants to proceed, commission can proceed in the manner which it believes appropriate.
okay, so it's 4:40. We have a hard stop at 5. So what is the feeling? Whether we want to take the next 20 minutes to deliberate and kind of get some things out there? And then if we don't reach a decision, we are able to do so next week on the 25th when we meet again, continue and finish. And I guess I'd like to know what everyone's thoughts are on that.
Madam Chair, if I may, mine would be that, obviously, my understanding is we have, Phil, correct me if I'm wrong, 30 days to deliberate.
Correct.
Okay, so instead of doing it kind of piecemeal, I'd rather have our discussions all at one time. That's just me. Instead of doing 10 minutes and breaking it up. I don't know how long it will take. And secondly, just to do my own due diligence, I would like time to review the file that I have. And I would ask that Mr. Richter send us, unless I have them, but I don't see the list of exhibits from both Mr. Hicks and O'Brien that was submitted. I mean, we don't have that, do we?
Yes.
You have it.
Yeah, I don't think it was ever provided to.
Right, I mean, I
all
would like to
people.
have
It's come to
that
me.
list just
I
to
think it was originally emailed to me.
check my,
So I have it on my
files
emails.
that I have
Yeah,
on this.
I don't think I ever circulated it to you as a part of the deliberations. It just wasn't appropriate.
no, I understand, we had to wait till they were submitted. I'll get that. But I would like to peruse those. That's just my opinion. And I think we, obviously we could do it, we have a hearing next Friday, or next Thursday, I'm sorry. No reason we couldn't do it then and take whatever time was needed to finish.
Are you recommending we don't ask any questions right now? Or
I think we
your
should,
deliberation amongst the commission members, are you
questions to,
here?
no, I'm not, I think it's fine to do that. I would just prefer our deliberations.
I'd be leery of asking any
You
more
would?
questions. It's a matter of deliberating amongst ourselves as to what we believe.
Okay,
You,
I'll
Paul, not
I'll
me.
defer to you. It's
Yeah,
our
but-
first,
Since they
What
pressed
you
it.
all
our actual
believe,
first hearing, so.
you know, is the appropriate approach to take.
Okay.
And whether you find a violation or not, if you find a violation, what the nature of the penalty is.
Okay.
Do
That-
you need this
that's
on the
what-
record?
Yes.
I guess my preference would be to at least deliberate a little bit now. If nothing else, perhaps hearing thoughts from some of the other commissioners may help me think about what I need to review or focus. I mean, I have some definite thoughts in my mind. I worry a little bit about, how much I'm gonna remember next week. Given the, extended time frame that we've done. And I think there's no harm in it. I doubt we get it in 15 minutes, but we can at least start to hear where some thoughts are and then we focus how we prepare for next week.
I would just want to throw out one concern about next week. I can make it, I do have a 2 o'clock appointment next Tuesday, so if we could possibly, if we don't conclude today, we could do it early. I don't know if that's possible. I usually know we usually do the rest of the business first, then this second. I just wanted to throw that out there, or hopefully next week will be pretty.
Yeah, the next week's meeting will not be as lengthy as it relates to the other matters as today's was. So I could end up being wrong, but I don't see the 2 o'clock timeline for you as being a problem.
Well, it is 2 o'clock when you would need, you could stay.
I have a meeting that I've got to be on the Zoom at 2 o'clock.
By Zoom,
If it's
okay.
not here, I've got a location in Columbus I can go
Got
to.
it.
So 1:30 would probably be when I'd have to
Well,
be.
part of the reason I ask, and apologies if I'm getting ahead of
Yep.
you, Madam Chair, we've talked about having our executive session really started next week, around your annual review.
Right.
So Commissioner Hagan has sent out a survey that we talked about, and hopefully, Executive Director, you could, last year I know you prepared thoughts and kind of that. If you could come prepared to do that, it'd be great. Mr. Cooke's gonna be here, he spent a lot of time.
But to that point, I just need to be here for the Hicks piece, so Ms. Davis would be handling.
Yeah, but you
Right,
could
you want me for
participate, you
this.
could participate in the discussion, and Mr. Stoutberg, if you could make it as well, I mean, that's great. I don't know what the rules are in terms of, just that, paying them I mean, but I mean,
It's
the
the first time
more,
we've had alternate members
Sure.
in order to come into the
we're kind of figuring out on the
consideration
fly, but I mean,
Right.
the more of us that are there to have it's a, executive session discussion, so it'll be outside of the public view. And then we can certainly, I shouldn't speak out of my, I would hope we could adjust when we do that around what makes sense with the schedule. Anyway, that's why I wanted to
No,
interject,
thanks.
because that would be great to do that. Well, we also want to do it before the, Madam Chair rolls off in a few weeks.
You want to start in, I can go either way. Do you want to start the deliberations now and pick up, or you just want to hold everything off until next week? What's your preference?
No, I do feel like, to Commissioner Knight's point, I think that if there's anything that you're afraid is gonna not, I think there's a lot of information to download, so if we could talk about some of it, whatever you feel is like first and foremost on your mind, that you wanna make sure that it's cemented in there, I think we should maybe have that conversation for the next 15 minutes. So, whoever would like to start or whatever, and then that way we also know what maybe we need to dig deeper into.
I'm fine, whatever the group wants, I'm fine with that.
So, I guess I'll begin with a few kind of thoughts. In terms of, Caraway and Ralph, I think that, they were paid for by the 10% markup. I mean, if you're going to call them in kind, you'd have to call everybody paid for by JPL in constant contact, would be in kind, right? Because why would it only be a subset of them? In terms of R.J. Mancini, I've got a couple of things that I'm trying to reconcile. One is the statute as described by Mr. Hicks, around once the complaint was filed, was there a duty to amend at that point? Representative Schmidt and her attorney obviously had access, they got the affidavit, and the affidavit clearly works around how it's positioned. So that certainly is a concern. Obviously, Mancini wasn't in kind. Probably should have been reported by the Republican Party, and she didn't know that. So the question on Mr. Schmidt is when did she have the duty? But since he was being directed by Tommy Ralph to do the door knocking, that's under GPL constant contact. So I think that might be part of the same 10% markup, right? In terms of the Goldstein piece, I think, certainly, I respect wanting to pay bills, absolutely. I know if it were me, once I was told, you know, you don't have any proof. I'm like, I'm not paying this, right? But I respect the viewpoint. In my mind, it would have been cleaner at that point because you could say, okay, there is no debt. But now that you've negotiated a settlement, now there is a debt, or at least there was. There were amendments made, but there was a violation, right, at that point. So feels like there was a violation in that dynamic. But I think Representative Schmidt has definitely, you know, tried to rectify things. You know, and a lot of times with this commission, we take all that into account, find good cause, find whatever it is. And I do believe that she, you know, sincerely has tried to do the right things over time. She called the Secretary of State, she asked for guidance. And these are kind of like one-off situations. So a lot of moving parts. I apologize for being long-winded, but I'm kind of giving you like the three silos as I see them and what I'm at least trying to reconcile.
Go ahead.
No, I agree, I just don't see a violation here at all. So the thing with RJ Mancini, again, if they had in-kinded that to her, and she took it and set it aside and didn't do anything, that's one thing. But nobody in-kinded RJ Mancini to her, so there's nothing there to work with. You know, in the reports, it's what did you know at that time? Truthful and accurate doesn't mean looking back you should have, could have, would have. It's what did you know and what did you do at that time? And I think that at that time, she wasn't in coordination with RJ Mancini.
Totally agree.
Yeah.
But is there a statutory requirement that once the complaint was made with all of that, did she have a requirement to investigate? Clearly had access, easy access to Mancini. She got the affidavit. They got the affidavit. Right. She could have asked the same questions Mr. Hick did
Right.
and got to the same
Right.
conclusion.
And
That's my,
Caraway-
I agree with everything, I'm saying, I don't know, that's where I get,
Per what's been put on the record, it was immediate to an attorney, which leads me to wonder, is this not the first instance of this sort between this dynamic? Because you may have normally pursued those things if it wasn't a situation that you'd experienced previously that would cause you to directly engage an attorney, which then limits your ability to access or seek things out on your own behalf. That's just an observation. I don't know if it's accurate or not, but that's an observation. And I would wonder then, if there is a violation of any sort, if it was established in this hearing and they've recognized that and reconciled it, maybe the violation or the fees would be associated between that point of recognition and then when that amendment was actually made and filed. And that's the window that seems most appropriate, at least from all of the options. I could be off on that, but that's.
But on the corporate thing though, I think there was a lot of cross testimony and very much lack of clarity, but there was an invoice which came out, whatever, a year and a half later, and it said UOX, and they said, you know, what do you mean? And they settled on an amount. At that point, there's not a forgiven part of it. It's a resolution of a disputed amount, and that is the amount that you owe, and that's the amount that you paid. Because there was then some talk about, well, then there's an in-kind contribution for the forgiven part. It's like, no, because if something's forgiven, you're saying that this is owed. You know, you're resolving a disputed amount and coming to an amendment. I'm sorry, coming to an agreement of what was owed, and that's what they did. So,
And
I
it
don't
was
see that
never
either.
clear whether it was just this company that was going underwater, that was doling out anything they could dole out to try to bail the water out of their own ship like
Right,
that.
right.
And everybody could have gotten arbitrary amounts. It was never made clear to any of us what was directly associated with those original amounts. So there's no way for us to say, yes, half was paid or all of it was paid. That's a gray area that exists for us as a commission.
I don't think forgiven is the right term. I
Correct.
think it's just been determined that this is what we believe. You, categorically, we can prove that the services, the product was provided to you this is what we can prove, the rest of it we can't prove, it's not forgiven, it's just we have no proof that we actually did this for you. So I think to say it's forgiven, it has to be reported as in kind, which is not allowed to be done by a corporation. I think that's where, you know, if someone says, oh, you know, I thought you bought 2 pairs of shoes, but you just bought one, I can't prove that you bought the other pair, well, you're not forgiving, you know, $100 off of that, you're saying, I can't prove that you have those shoes. It's the same thing, only it's obviously, you know, a product that we can't put our hands on as, you know, a tangible item. So I think forgiven is the wrong term to be used in any of that. So I think that definitely needs to be taken into consideration, because then it's not an in-kind corporate gift that is, you know, something that's not allowed by law. So that's the thing, I guess, that stands out most to me about the whole constant content and JPL. Is that to me is, if Mr. Goldstein says, this is what I can prove, that's what we have to take his word for, because that's what he was paid to do.
But he couldn't prove anything.
Right.
Mr. Goldstein, his business model is real simple, right? Whatever he gets a percentage of it,
Yeah, as the
right?
attorney.
And so, you know, when she said she'd pay half, he's jumping for joy, because he was probably figuring, right, like all the other, you know, people he talked to, they were gonna fight for 0, he gets 0. So, I mean, I'm sure he jumped right on that.
Right.
What is that? I think the challenge is there's not a statutory place for this, which is why you called the Secretary of State's office looking for guidance, I imagine.
So really, she could have paid 0, and it was because he couldn't prove anything.
Yeah.
He's just looking at a piece of paper, and that's what he went by. So.
4 minutes.
Was there ever material evidence that those mailers were manifest into mailboxes, or was it just that one piece that we ever saw that had no marking? I heard a little bit about John Becker, but I don't know where that.
Ms. Schmidt indicated there were 4
And I know
that
John
she
Becker.
received. Ms. Schmidt indicated there were 4 that she received. Let's put it that way. Amongst the 7 that were identified.
Okay.
And there are 3 that I say, you know, there's disputed testimony, let's put it that way, I guess is the best approach.
I think that's the question of the executive director. What is your perspective on Mr. Hicks's interpretation of the statute around once the complaint was made and there was some level of potential proof, was there a duty to investigate at that point?
I don't know if there's ever a duty to investigate based on the statutes. Generally speaking, and this is generally speaking, I think most campaigns wait for an addendum letter to come back from the office where they submitted the report. You know, so you file a report with the Secretary's office, they do the audit, they send you back a letter saying, hey, here are the discrepancies that we have found in your campaign finance report. Certainly, the filing of a complaint or bringing something to someone's attention is an event that occurred, but we have never been put in a situation to determine that that is sufficient to, you know, to essentially start the clock running, let's put it that way. That's never been something that we've decided. Maybe we can do it here, you know, but it's not something we've decided. Generally speaking, it's a matter of the official office getting back to you and saying, here are the discrepancies that we have identified, please rectify these identities. And that is statutorily when your obligation to within 21 days file an addendum to your campaign finance report. You know, certainly I think there's something to what Mr. Hicks has presented to us in terms of bringing it to the attention. Alternatively, I would, you know, I mean, you've got to respect Mr. O'Brien's argument, you know, in terms of, you know, what does that really mean? And, you know, does that place an obligation? And I would say specifically it doesn't, but it certainly does raise the question of, you know, when does that start? So I realize I'm not giving you a great answer.
I don't think there is
because
one.
There isn't a great answer, you know, because the simple answer is you wait to get the addendum letter. I mean, that's the simple answer, but this kind of situation changes that a little bit. You know, because they didn't get an addendum, I don't know, maybe they did get an addendum letter for something else that wasn't included, but as it related to this, I don't think they ever got an addendum letter from the Secretary's office saying, hey, here's a shortcoming, et cetera. They took the extra effort to go ahead and file something after, you know, after they recognized that there could be something out there.
I think, I'm sorry.
I was just ending this up.
And I think you know, I don't think it is lost on me anyway that we are a compliance-driven, you know, body. You know, yes, we have to there has to be penalties, there has to be things when we recognize that there's something that's been done wrong. But also, in my almost 5 years on the commission, we've seen people that even when you put something in front of them that is categorically undeniable proof that they've done something wrong, they will deny it till the bitter end. And, you know, can't understand why they've been assessed a fine and found a violation. I think that it needs to be, I guess, I am heartened by the fact that Ms. Schmidt has really tried to rectify anything that she has seen or has been brought to her attention, and she's tried to rectify it. Maybe it's not in the timeline that you know, Mr. Hicks would like to see, but the fact of the matter is that, you know, when something has been brought to her attention, she has tried to go back out and rectify it and, you know, file the proper paperwork. And I think that goes to knowingly, you know, having something that she feels she owes. So, you know, while maybe there's a violation, maybe there's a punishment that we need to, you know, or not a punishment, but a penalty, you know, I think that we've always said we are a compliance-driven body. So do we have to have punishments and penalties for things that are done wrong? Yes, but there are plenty of times when we look at something and we say this is the first time or the second time or the 12th time or the whatever, and that goes to kind of how we assess the situation.
Madam Chair, I apologize, I have to run, but
Okay.
2 quick things for Phil. Just a reminder to please send those exhibits if you would.
Yep.
And our standard of proof here is preponderance of evidence, is that correct?
That is correct.
Which is just the tipping of the scales, right?
Correct, that is correct.
Okay. That's all I need, thank you. I apologize, I have to run, but I gotta
That's
run.
okay, so should we adjourn at this point?
I would think that would be appropriate.
Okay, so can we have a motion to adjourn?
So moved.
Second.
All right, we have a motion to adjourn, that's been duly seconded. All in favor, signify by saying aye.
Aye.
Pose same sign, motion carries with a vote of set 6 to 0, sorry. So now this, I know, I'm just gonna go.
Uh,
Thank you very much.
Thank you.